I want to now turn it over to our co-host. Thank you for having us today, by the way, Courtney. This is Courtney Buchan over from GRS Community Management. Courtney, take it away, my friend.
Thank you, Jeff. Thank you for the nice introduction. Hi, my name is Courtney Buchan. I'm the corporate trainer for GRS Community Management. I'm also a board member myself and a licensed CAM. So a little bit about GRS. We're a mid-sized management company based out of Lake Worth, Florida. We also just opened an office in Jupiter, Florida. We've been providing great, reliable service since 1989. We help handle all facets of community management all across our state. So if you're happy with your current management company, great. If you're not, give us a call, or you can check out our website at grsmgt.com. We have a lot of information and resources on our website. We love doing these classes for board members and CAMs. You can also follow us on our social medias. So today's class, I had the pleasure of attending live in person with Ben and Jeff from K. Bender Rembaum. Very great class, very informative, very important if you're doing a construction project. There's so much that goes into it, and there's so much that can go wrong. So funding construction projects and construction contracts is very important. So I'm glad everybody's here today. I want to give a big thank you to Jeff Rembaum and Ben Heidluck from K. Bender. They're based out of their Palm Beach Gardens office, my favorite office. I'm based out of Palm Beach Gardens. So thank you so much for doing today's course. I hope everyone gets a lot out of it. I hope we have a lot of GRS board members and community managers on today's call. So with that being said, I'll turn it over to Jeff to get us started.
Thanks. Thank you very much, Courtney. I'm going to reiterate what you said, that if you're happy with your manager, stay put. But if you guys are, anybody out there is considering new management, you definitely want to have GRS on your radar, give them an opportunity as well. And I'll say the same for law firms. If you guys are happy with your law firm, no need to look around. But if you're looking, Courtney, what's the name of our law firm again? Courtney? Oh, she's gone.
Can we read lips?
Sorry, no. K. Bender, I had myself on mute. Sorry, got a little ahead of K. Bender Rembaum, attorneys at law.
There it is, K. Bender Rembaum. See, in the old days, it was K and Rogers, then it was K and Bender, then it was K. Bender Rembaum. I always have to, because I'm the third one there, right? It was almost K. Rembaum Bender, but I gave in to Michael at the end. That's a story from 12 years ago. We have a lot of fun with that. But, you know, I'm sensitive to that third name for reasons I can't explain. Many of you may be wondering about the board member certification, the continuing education credits, not CERT, not board member CERT. And by the way, I'm a board member too. You'd think I'd know better, but like Courtney, I too am on a HOA board. So I not only live it as an attorney, but then when I go home, I get the pleasure of dealing with my community and all of our issues. So I sort of know it from both sides. Let's see, some housekeeping matters for everybody. K. Bender Rembaum, most of you know us, but in case you don't, and it's your first time, we are a full-blown community association law firm with what I refer to as a full-blown litigation department, including construction litigation, where my partner, Jeff Green, is board certified in the field. We have a foreclosure, collection foreclosure department, which is just fantastic. Everything is posted online for you. You never have to call and ask the attorney what's going on. You log in with a simple password, username, and all of the information that I have access to, you would have access to as well in terms of the status of the case. And then we have the desk practice, which is everything else that you could possibly think of under the sun. Regarding the board member continuing education requirements, the DBPR has not approved them yet. So for those of you that are wondering, how am I going to complete them? Well, until DBPR approves the courses, nothing for any of us to do. So just bear that in mind. And I think that pretty much covers the housekeeping. We're in Pompano Beach, Palm Beach Gardens, Tampa, Orlando, and pretty much anywhere in the state of Florida you need us to be. I'm here with attorney Ben Heidluck from our firm. Ben is really a maven when it comes to construction contracts and construction contract terms and all that good stuff. You're going to hear mostly from him today. I'm here for just a little bit of an introduction on the funding of the construction projects, and we'll talk about a few things there. But I also want you to think about the upcoming legislation. Now, the upcoming bill that we have not heard that it's been approved by the governor yet, House Bill, let's see, we're talking about 913, we do expect it to become law. And it will allow for the borrowing of funds with certain criteria, prerequisites, but there will be a mechanism to borrow monies to fund CEUs, either through a direct loan, lines of credit, that sort of thing. But they're going to be legislative in the statutory hoops you have to jump through. And there could also be some governing document requirements when it comes to borrowing money. So you'll have to make sure both are all the check boxes, if you will, for your governing documents and for the statute when it comes online, expecting it to come online, are that you follow them. So as I talk about borrowing money today, we could equally apply these same information to that as well. All right, with that, I'm going to share my screen because I don't think you all can see it as yet. So let's see, here we go, Microsoft PowerPoint, share. Hopefully now, Ben, a shake of the head there because I see you, it's on the screen. Fantastic. Is it taking up the full screen? What view are we on here? Am I on presenter view?
It is a small center image.
We see your view with the notes at the bottom.
You do. You should not be seeing my notes at the bottom. Let's see what we can do about that slideshow, and we will. That's good there. So we just need to play from start. Presenter view. There we go. You're probably going to get the presenter view. I don't know. Anybody?
We see the slide with a thumbnail that says next slide on the right. It's not full screen yet.
Okay, one moment. We're going to make a change on my side and we will fix that for everybody. All right. How about now?
Perfect.
All
Perfect.
right. Good, good, good. Okay, so we've covered our housekeeping. We're ready to jump into the core material. If you are thinking about doing a construction project, it really doesn't matter if it's a $20,000 project or a $2 million project. That which can go wrong sometimes does go wrong. And the problems you will encounter, whether it's a $20,000 contract or a $2 million contract, in terms of the legal fees to fix the problem, are pretty much the same. So if you have a breach of contract problem, in order for us to fix it, really the work on our side is the same. So where am I going with this? An ounce of prevention is worth a pound of cure. What you want to do is have a contract, the contract you want to use for the job, and have that as part of your bid materials so that there's no question, and Ben will cover this in depth, but there's no question that you at the association don't want to use the AIA contract. You will hear from the contractors, oh, it's a fair contract. And it is, it's very fair to them. We prefer a more hand-tailored construction contract that equalizes, if you will, the risks, liability, and really favors more so the association than the contractor, which is why we prefer using our contract that really, you don't know if you have a construction dispute and you're in a courtroom, well, what is the background of the judge? And if you're using the AIA contract and they don't have the experience to know how to navigate that very unwieldy document, that could work to the detriment of the association. Whereas if you have in plain English a construction contract where all the terms are spelled out such that a high school senior could read it and really make good headway in understanding it, that's really what you want. So bear that in mind, and Ben will cover that in a lot more detail. Moving into why do we need to borrow these monies? Well, let's face it, if we're doing a large concrete restoration project, life safety code upgrades, upgrading the building, the elevator retrofit, a seawall that can cost, gosh, when I last worked on I had a seawall issue, it was $10,000 per, I think it was per foot for a particular client where the seawall was a particular length that was quite large, but that can be a very expensive project very quickly. Also, we have emergency mitigation, right? Let's say, God forbid, we have a storm and the building takes a hit. We have to be prepared and ready to roll in terms of how we're going to attack restoring the building, which obviously boils back down into money. So sometimes you want to borrow that money or have a line of credit ready to go. The sources for the money could be the annual budget, could be special assessments, could be reserves, and it could be financing. Remember, with the structural integrity reserves, no longer can you have a membership vote to use those monies for a different purpose. They can only be used for their intended purposes within the pool, if you will, of the structural reserves. You can take a vote of the membership, however, now it's a majority of all, to use the non-statutory, the non-CEUs reserves for a different purpose by a vote of the membership. Is a joke, sort of, we tell, what do you do when a community set of documents requires the membership vote for a special assessment? What's the end run around that if the community can't vote to get it done? Amend the annual budget following the budgetary adoption process. Typically a 14-day meeting notice, and the board can amend the budget if necessary. But obviously special assessments are really for those one-off projects that go outside the anticipated scope of what the budget was for in the first place. When we're dealing with special assessments, oftentimes it can take a vote of the membership to enact that special assessment. Sometimes it is simply up to the board of directors. When you're borrowing monies, sometimes the lender will collateralize that loan, right? They want some kind of collateral, and it's either going to be a promise from the board that in each year's successive budget, there will be a line item for the funding of whatever the payback requirements are for that particular year, and you will repay the loan through the annual budget process. More and more lenders are doing that, and I like that, because the alternative to that is the special assessment. And when we're dealing with the special assessment and you need a vote of the membership to do that, sometimes the members won't vote in favor of it, which brings us to what I refer to as the Tiffany Plaza progeny of cases. Here, we're dealing with a material alteration and the need to borrow money and funds, and the board had to levy a special assessment against the membership to put essentially a rock revetment wall in the Atlantic Ocean. So I want you to just picture a whole bunch of rocks put about 50 yards offshore, maybe, to break the surf before the water from the ocean would hit the building on a high tide basis. Building engineer said, listen, you need a rock revetment wall to break the surface, to break the waves. You also need to shore up your foundation. And this was a very expensive project. The board went to the membership for the vote for the material alteration and assessment, et cetera, and it didn't happen. The board said, well, we still, to quote John Wayne, you got to do what you got to do. So the board levied it. And what do you think the upset members did? They filed lawsuits at this court. These court cases found their way to the district courts of appeal, where the district courts of appeal, and I will paraphrase, basically said, when you have issues that are life safety at issue, then board members, you need to do what you need to do to protect the building and to protect the people that live in the building. And hence they got the power from those court cases to do the material alteration, the end run around the documents, to levy the special assessment against the membership. But what it doesn't do, where we haven't gone yet, is it does not provide the direct legal authority to be able to borrow the money. So in that circumstance, those special assessments had to be paid back by the membership directly without an intervening loan to take some of the financial burden off. Though I suppose you could, at that point, once the members understand you're going to effectuate the material alteration, you're going to adopt the special assessment because we have these maintenance requirements, right, for life safety. Well, then maybe you present an opportunity to the membership to borrow the money to offset the special assessment funding requirements for those that need that financial help. So that is something to think about. All right, I think we've covered that ad nauseum. Moving on, budgets and reserves. You're going to have your reserve studies. A little prelude to that, we talked about how this new legislation will, if adopted into law, provide opportunity to borrow money to offset some of the structural integrity reserve funding requirements. That's a good thing. Remember, you have pooled versus straight line reserves, reserve expenditures, transferring reserve funds. We talked about that already, that you can't take the vote except for the non-structural reserves. And there you can use that money for a different purpose, but not for the structural integrity reserves. If you're starting out with your structural integrity reserves and you want to pool them in the beginning, that is just fine. There's no issue there. Remember, if you are going to use pooling, then you certainly need the calculations from a reserve specialist so that you always have enough money in the pooled reserve at any given time, as compared to the straight line reserve, which will require a lot more funding obligations if you go that direction. So just know that the reserve specialists and experts can certainly show you the funding differences if you go pooled versus going straight line. Special assessments, contents, timing of the notice, limitation, and the governing documents. So we have to comply with law. We have to comply with the requirements in the governing documents. The law is our starting place, but if the governing documents require a greater notice period than what the law provides, then you're going to need to follow that greater notice period. For example, law says you need a 14-day membership notice going out to everybody. So let's say that hypothetically, we'll make it up as we go for a minute, the board has the power to levy the special assessment. Fine, it's going to be at a board meeting, but it's not a 48-hour notice board meeting. It is a 14-day notice board meeting where all of the members have to be provided notice at their official address, however that may be, whether it is through US mail, whether it is through email, whatever the flavor of the association is for providing the official notices, but it would be a 14-day meeting notice requirement. You must list out these amount of the special assessment, what its uses and purposes are going to be. But however, if your governing documents require a greater notice period, maybe a 30-day period, then you'll need to comply with that as well. So bear that in mind. When it comes to the financing, these are the things we look at, right? Loans and the credit lines, the authority of the association to incur the debt, qualifications, criteria for that particular association, and whether we have board versus membership approval. And we talked a little bit about those issues already. Really, what I need you to take away from this particular slide is oftentimes the lenders want an opinion of counsel. So if your governing documents required a vote of the membership for the material alteration, if they needed it to levy the special assessment, but the lawyer says, no, wait, these are life safety issues, then the lawyer needs a letter from your association's expert, the engineer, whoever is scoping the job, to really put a letter together explaining the necessity and life safety issues that are at hand. With that, the lawyer can then write an opinion and say to the lender, notwithstanding all these requirements set out in the association's governing documents, the association can effectuate this material alteration because, and the association can, if you will, take a vote for the special assessment by the board, even though membership might otherwise be required when it's a life safety issue. But at the moment, when the documents still require a membership vote to borrow, you will still be stuck with that limitation. So if your governing documents say you cannot borrow money absent an approval by the membership, then you will need the membership approval. And if you don't get the membership approval to borrow the money, well, you've got the material alteration, that will pass. You've got the special assessment to fund it, that will pass, but you won't be able to borrow the money, and that could create additional financial obligation on behalf of the members that could have been offset and spread out over a period of time had the membership voted in favor. Usually, when you bring this to the attention of the membership, the light bulb goes off and they will support what the board is trying to do, because really that loan is to help all those members who cannot afford the one lump sum or two lump sum, whatever it may be, special assessment. So rather, they need to spread it out over a period of time. The interest associated with the loan does not have to be shared by everybody, including those who didn't borrow the money. So the interest for the loan can be shared only with those people who are borrowing the money. So if Joe has the money in his bank account and strokes the check to the association for his share of the special assessment, he's done. He doesn't have to pay the interest associated with the loan. The only people paying the interest associated with the loan will be those people who are actually taking advantage of borrowing those monies to spread out their obligations over a longer period of time. The opinion of counsel letter is quite lengthy in terms of what we have to provide to the lender, and it takes substantial time to put that together. So bear that in mind, and that could cost anywhere from $1,500 to $5,000, depending on what the give or take, depending upon what the lender's requirements are. But if you're dealing with a multi-million-dollar loan in regard to the project itself, the legal fees associated are de minimis at best. So just bear all that in mind. Now, we have the commitment letter, the typical loan documents, the collateral, and the closing costs. All right, where am I going with this? The commitment letter. Really, you should be involving your lawyer before the board signs the commitment letter. I can't tell you how many times the board will sign a commitment letter, then they send it to me with their signature on it, and the collateral that the lender wants is just wrong. You cannot collateralize really. What the only thing you should be collateralizing is a special assessment or the assessment regime, the general assessments. But when it comes to the real property, if you will, of the association, as well as the personal property of the association, those are inappropriate. What about insurance proceeds? Don't you want to exclude that from the collateral, right? You do. So there are things to think about that you really need legal counsel for when it comes to the commitment letter, so that those items can be squared away sooner rather than later. Because if the commitment letter is signed, then we know the loan documents are going to be wrong from the get-go, and all that has to be negotiated and fixed before we can move forward with the loan. That takes time. Time costs money. So really, if you involve the lawyer sooner, they can look at that commitment letter, look at the collateral, and try to work all those issues out so that the commitment letter is actually correct, meaning the loan documents will be correct. And that's good, because that'll keep legal costs down. Of course, you're going to have the closing costs, which are going to be the legal opinion from the lawyer, the recording, the documentary stamps, whatever the lender's origination fees are, et cetera, et cetera. It's just to be expected. When it comes to funding it, we've already talked about that. With the project itself, let's say we're doing a concrete restoration project. Well, it could be done through a special assessment. We could amend the annual budget as well. And sometimes the loans have prepayment penalties, but if you discuss that with the lender, more and more often they're saying, well, no, they'll get rid of the prepayment penalties. Not all the time, but many times. The only time the membership is involved, let's say the entirety of the membership is involved with the loan, is if there would be, God forbid, a default. Now, I've been doing this for almost 30 years, practicing association law, and I have yet to see an association go into a default situation. But I have been asked the question as follows: hey, Jeff, I'm going to pay the special assessment. I don't need to borrow any money or be a part of the association's borrowing of money, because I'm going to pay my share. But what happens if the association defaults on the loan? If that happens, then the repayment to the lender, their rights are against all of the members within the association, not just those who actually borrowed the money. And that's a conversation you can have with your legal counsel, should it be necessary. But generally speaking, the loan is paid back simply by those people who took advantage of being in the pool to borrow the money to spread out their special assessment obligation over a period of time. They will pay the loan back, they will pay the interest back, and then if, God forbid, there's ever a default, then all of the members could be involved in having to pay their share of the default. But again, in 30 years of doing this, I haven't seen that happen. So I'm hopeful I can make it to the end of my career without ever having seen that happen as well. And that takes us to construction contracts and why we need them, which we're going to hear from attorney Ben Heidloff. And he's going to start out with, there's no such thing as a standard contract. Ben, I'm turning it over to you. I'm going to turn off my shared screen just as soon as I can figure out how to do it. And it'll be all yours.
Thank you, good sir. And when you shut yours off, I will then share mine. And hopefully we'll get a confirmation that all looks good.
And while the gentlemen are doing that, just a quick reminder, if you haven't already pressed the chat button, press it once, simply so it shows up. Don't worry if it says chat is disabled. We can still send stuff your way. And that is where we'll place the link for the evaluation later. And after you submit that required evaluation, you will have access to download the slides and everybody's contact information, as well as all of our upcoming events for the rest of the month.
Jeff, I'm
Back to
going to
you.
put you on the spot real quick.
Yep.
Is it possible to open the chat for questions? If we have time at the end, we could actually try to address them, or will that mess up your plans to send the forms out?
The Q&A is open right now for questions, everybody, and there's been a few in there that I've been answering.
All right, good. So we'll, Ben, maybe at the end of this, we can come back into it and answer some questions.
Sure, be happy to. Either Jeff and or Courtney, how is my PDF looking for you all?
It looks good.
Okay, fantastic. Well, good morning, everybody. As Jeff mentioned, I am attorney Ben Heidloff. I too am one of 22 or so attorneys here at K. Bender Rembaum. And as Jeff and Courtney mentioned previously, somehow, some way, they are serving as board members. I, on the other hand, live way out west in the land of freedom called Loxahatchee. And we know nothing about these HOAs or condominium associations. So after a hard day of practicing community association law, I get to drive home and park my car on my front lawn just because I can. It is fantastic.
Sure, rub it in, pal. Rub it in.
Ah,
rub it
sorry, I
in
just
more,
had
Ben.
to.
Gosh.
Sorry.
Lucky.
So now that we have a little bit better understanding of construction fundings, we're going to jump into more specifics regarding the actual construction contracts and why do they need them. Now, I'm sure you're all familiar with that saying, life pro tips, such as don't place your tongue on a 9-volt battery. But as we move through these slides, I'm going to share with you contract pro tips. Because this is all good information for you to know. The first of which, as Jeff alluded to, is there's no such thing as a standard contract. And by show of hands, even though I will not be able to see them, how many of you CAMs and or board members have actually signed a contract without any legal review? Oh boy. It's much worse than I expected. I'm so sorry. Well, you should not be doing that. There is no such thing as a standard contract. We find that when we review contracts, the overwhelming majority, if not all, of vendor contracts are missing very important protections for the association, whether it's in regard to assurance and requirements, indemnity requirements, termination, standard of the work. We find more often than not that any quote unquote standard contract that we are presented with needs a little bit of massaging. Jeff also mentioned a little bit about the AIA contracts, which is the American Institute of Architect contracts. Now, many of you may be familiar with these, and Jeff had mentioned oftentimes the engineering, the architect, or the contractor argues that these particular contracts are fair and balanced. Well, certainly they're fair and balanced to one party to the contract, and that typically is not the association. Additionally, the AIA contracts are written to apply to the broadest possible audience, to apply to the broadest possible facts. They are not state specific, and they generally include language that is so generalized, it really does not always address the specifics of the particular contract or project that the association is thinking about engaging in. And probably most offensive of all is that these AIA contracts reside behind a paywall. Meaning, if you want to see what's in the contract, you actually have to go to their website and you have to pay to play. For instance, some of their short form standard agreements between owner and contractor can cost upwards of $150. Additionally, the AIA contracts also include references to other AIA documents that you or the board members probably have not received from the contractor and probably have never read, and include other important terms and conditions. So a lot of times when the association ends up signing these AIA contracts, they really don't know to the extent of what they're actually signing on the dotted line for. So got to always watch out for that. So there's some options for the association to get around these AIA contracts. And as Jeff has mentioned previously, one of the ways is including an actual construction agreement in your bid package, in your request for proposals that go out to these contractors. Hopefully you can all see, I'll hold it a little bit higher. But we actually draft construction agreements on behalf of our clients as appropriate. Another option is to present an addendum to the contractor's contract that will control the terms to the contrary that are included in the contractor's contract. So that's potentially another way you can approach it. Or finally, sometimes, depending on the amount of information in the contract, if there's just a few corrections that we need to make, or maybe we would like to have some preferred language added to that contractor's contract, we'll actually do our red line revisions directly in the contract. So those are all ways that you can contract, no pun intended, around the AIA contract. Now, there's some certain important terms in any construction contract, and we will get to these as we progress through the slides. But we're going to be talking about notice of commencement, notice to owner, waivers and releases of lien, indemnity, insurance that we want to see the contractor carry, builder's risk insurance, the importance of workers' compensation insurance, change orders. How do we effectively make changes to the contract? We'll discuss a little bit about payment and performance bonds, and then we're going to talk about termination. And it's interesting as I look at these categories more, these could all be categories for a good jeopardy. It's interesting. Starting with the notice of commencement. So this really is putting the world on notice that the construction fun and festivities are about to begin. And it's really a document that's executed by the property owner. In this case, it's more than likely going to be the association. And it really formally designates when the construction project starts. It provides important information regarding the particular project. It's used by all the subcontractors, suppliers, so that they can prepare their notice to owners, which we'll talk about in just a moment. And it helps to establish the priority of lien claims. And it really helps also ensure that the association does not pay twice for improvements to the property. And we'll talk about that in a little more detail in some slides to come. In that bottom portion, you'll see that the association completes and records the notice of commencement in the official records of the county where the association is located. Now, when we talk about payment and performance bonds, it's important to know that if the association decides to have the contractor procure those payment and performance bonds, that those need to also be recorded, and they're recorded as an exhibit to the notice of commencement. It's also important to know that the notice of commencement actually has an expiration on it. More often than not, they are good for 1 year. So if your association is going through a project that's going to last more than 1 year, you want to notate that either on the first notice of commencement that's being recorded, or make sure you update the notice of commencement. And then notice to owner. So this is for the subcontractors, material men, and suppliers that provide labor or materials on behalf of the subcontractor. And this is really a recorded document that's done by the subcontractor suppliers. And it lets the property owner, again, the association, it lets the general contractor and other parties that are involved that are providing, whether it be labor, materials, or service to the project. And it basically protects that entity's right to file a lien against the property if they're not paid for the work of materials. So for example, if I owned a business called Ben's Building Blocks and I was providing material to an association, I would want to make sure that I completed a notice to owner. And I'm going to record that again in the county where the project is taking place. I'm going to send a copy to the contractor, and then I'm also going to send a copy to the association. And then in that second, in that second box, you'll see the notice to owner informs the property owner regarding payment receipts that are needed from the contractor. And this third box at the bottom, here we go with a contract pro tip. So keep an eye out for this. If the association receives a notice to owner, but does not receive a partial or complete release of lien receipt from the contractor, the association could end up paying twice for that work. And here's what I mean by that. So if I, as Ben's Building Blocks, do my notice to owner and give it to the association knows that I'm supplying materials for the project. Now, the contractor is going to come to the association with their application for payment, and they're going to include releases of liens for all of the subcontractors and material suppliers. So if there's company A, B, and C, and the association only receives a release of lien, let's say for companies A and B, what happened to company C? Maybe that was Ben's Building Blocks. So that will put the association on notice that perhaps the contractor has not paid company C. So just another thing to keep an eye out for and watch for and keep track of as the project progresses. Another important area is waivers and releases of lien. Now, these are documents that are used to essentially relinquish the right to file the subcontractor and the material suppliers to file a mechanics lien, also known as a contractor's lien, against the property in exchange for payment. And then a good construction contract will provide as a condition precedent, meaning condition previous or before, each payment required by the contractor from the association, that the contractor actually submit to the association a sworn and certified progress payment affidavit that states under oath that all subcontractors, suppliers, and anybody that's dealing with the contractor has actually been paid through the date of the affidavit. So if you're one of our clients and we've actually drafted a construction agreement for you, you'll actually see that language in the contract. We want to make sure that everybody has been paid up through the current date. However, there's a couple of other possible scenarios that might arise. And certain attorneys feel different on this, and certain contractors can be a little wily when it comes to this. So one of the other possible scenarios that could arise is the contractor says, hey, look, I'm happy to give you this payment affidavit, but only through the prior payment. And so there is a gap of time between the association paying the contractor and when the contractor actually pays its subcontractors and material suppliers. Now, typically that time period is 30 days because more often than not, the contractor is submitting an application for payment every 30 days. So it's important for you all to know that during that 30-day gap, it presents a financial risk to the association. Because although the contractor has basically stated under oath that, hey, I've paid up through the last payment, I have not sworn that I have paid all of my subcontractors and material men for the current 30-day or whatever length of time period that may be. So in that event, it is possible for a subcontractor, again, if it was Ben's Building Blocks, If I was not paid by the contractor, guess who I'm going to be turning to get paid when I deliver materials? I'm going to be turning to the association. So that is an example of where the association could potentially end up paying twice. They've already paid the contractor for that particular application of payment, but for some reason, the contractor has not paid the sub, and the sub is now looking to the association to get paid. Another possible scenario, and we've had this happen, is the contractor says, okay, well, I'll give you that payment affidavit, but not until the association check clears my account. So again, that doesn't happen instantaneously, probably less than 30 days, but there is again a danger to the association that during that time period, perhaps the contractor has not paid its subs or material suppliers. So more often than not, if there's any way possible, we will talk with the particular contractor or the contractor's legal counsel to ensure that the association has everything that it's needed through that current pay date. Indemnity, this is another very important provision, and oftentimes we see when we get contracts from contractors that the indemnity provision is either missing or it's so one-sided to the favor of the contractor. And in essence, indemnity refers to the protection or compensation against loss or damage. Essentially, it's a way to transfer responsibility from one party to another in the event of loss. And think about it this way: indemnity is the responsibility to make someone whole, okay? And often in our indemnity provisions, we want to make sure that the contractor is indemnifying not only the association, but its agents, the employees, the members, the officers, in regards to particular kinds of losses. And in that second box, here's another contract pro tip. There's some language here in the parentheses that starts with including appeals, if any, along with attorney's fees and costs incurred in quantifying the amount of recoverable attorney's fees and costs. So many times throughout our construction agreements, you will see where the prevailing party is entitled to their attorney's fees and costs. This is important language that we've added because a lot of times, Lord forbid, if there is litigation, okay, and there's a construction defect claim or some other type of claim that arises, and the association ends up in litigation, it can cost thousands of dollars just to have an accountant or some other professional calculate what the actual attorney's fees and costs are that are recoverable. I know it sounds crazy, but when you're dealing with 6 and 7 figure litigation, trying to figure out the attorney's fees that you're entitled to, it takes someone a lot of time to go through the paperwork. So we want to make sure that the association can recover for that as well. And there's a case out there that says, hey, look, if that particular language is not in your agreement, then you're not entitled to it. So that's the particular reason we include this very specific language in our contract. And then down in the very bottom box, it talks about indemnification should not be limited to a specific dollar amount. And so when we draft contracts, we want to try ensure that the contractor's indemnity obligation to the association is not limited by the amount of the insurance that the contractor carries or any other limitations on any other policies that the contractor might carry. We want it to be what we would say monetarily unlimited. However, sometimes we get pushback on that by an astute contractor or their attorney, and sometimes we'll have to negotiate that down to perhaps the limits of insurance that are required to be carried under that particular agreement. But whether or not to accept those types of provisions or that type of language is ultimately a business decision for the board to make using its reasonable business judgment. Boy, another important area. Goodness gracious. Insurance. So really, we all know what insurance is. It really is designed to protect against a financial loss or some other type of specified peril. And we want to see in a good construction contract that minimally the contractor is required to carry some type of commercial general liability insurance, workers' compensation insurance, and automobile liability insurance, whether that is for owned, non-owned, or lease vehicles. Another important thing to look for is we want to make sure that the association is listed as an additional insured under the contractor's liability policy, as opposed to simply being listed as a certificate holder. And this is incredibly important. Boy, oh boy, if this was a contract pro tip, it would be capitalized with an exclamation point. So being a certificate holder on the contractor's insurance simply entitles the association to receive notice if and when the contractor changes or cancels their insurance coverage. What it doesn't do is confer any of the contractor's insurance benefits to the association. Now, conversely, being named as an additional insured actually confers the contractor's protections under that insurance policy to the association. Now, the big advantage of this is in the event of the loss, the association would be able to file a claim directly on the contractor's insurance policy. So it's incredibly important. A lot of times, we'll get certificates of insurance in from associations. They're so excited to sign a contract. They'll send the certificate of insurance in. We'll review it. And then we find, oh, their association is only named as a certificate holder. Please go back, have the contractor talk to their insurance agent. We want to make sure the association is named as an actual additional insured. And then certificate of insurance, this is another important point, are also limited as to time. They also have expiration dates. Typically, they're good for the current term of the policy. Generally, they're not good for more than 1 year. So in the event the association is in a construction project, let's say, for example, something that might take longer than a year to complete. One that instantly comes to mind is concrete restoration. Boy, those of you in the almighty towers that have gone through a concrete restoration job, kudos to you, because it does take quite a bit of time. So this is important for the association to ensure that prior to the expiration date of the current certificate of insurance, the association goes back to the contractor and asks for updated certificates of insurance. Why? Well, we want to make sure, number one, that the contractor's insurance is still in force, that the appropriate policy limits are still in place, and that the association still continues to be named as an additional insured on the contractor's policy. Down at the bottom, builder's risk insurance. So this is actually an insurance policy that the association may potentially take out. It's also known as course of construction insurance. And it's really designed to help protect buildings that are under construction. The policies vary between providers and the coverages vary, but typically these type of policies cover damages to property that results from acts of God, fire, lightning, hail, explosions, theft, vandalism. So we always encourage that the associations actually have a discussion with their insurance agent when they're going in and signing a construction agreement to see if builder's risk insurance is appropriate for the insurance.
Ben, I would also add to builder's risk insurance that if for some reason the builder goes out of business in the middle of the job, then builder's risk will come in. The association will still be obligated to pay what was initially in that contract for those amounts. But if it goes over that amount because they had to bring in a substitute contractor, that builder's risk then comes in as well. So that's also good to have there.
and workers' compensation. So this is another important area. And really, the important thing to know about workers' compensation is we want to make sure that nobody that is performing the work is not covered by workers' compensation insurance. You know, God forbid someone is working for the contractor, for the subcontractor, delivering materials to the site, doing some type of work, and they're not covered by workers' compensation, and they're injured on association property. And that takes us right down to that highlighted question there. What happens if a worker who is exempt from workers' compensation gets injured while on association property? Well, I will tell you, it's any personal injury or workers' comp attorney that is worth his or her salt is going to be looking to sue each and every deep pocket. And one of those deep pockets is the association. So it's very important in all of these contracts, and it's included in our construction agreements. We specifically outline the obligation for the contractor to not only carry certain levels of workers' compensation insurance, but also to ensure that nobody that's performing the work is not covered. And then change orders. This is really the process of, hey, we want to change something. The contract price was A. Due to this change, it's going to become B. And perhaps there's an extension of time that needs to be included as well. So these change orders are really formal written amendments to the contract. They modify the original terms of the contract. And they really lay out the scope of work, costs, scheduling of that particular change. And so when we look at a good construction contract, we look to see that the change orders are signed by both parties, or there's a requirement that the change orders need to be signed by both parties as opposed to just simply being signed by one party. And we want to make sure that if there's an appropriate adjustment to the contract price, it's included in that change order. If there needs to be an adjustment to the length of time for the contract, that's in there as well. And then you'll see in number one, even though I kind of skipped over and went to Roman numeral number 2 first, sometimes we see language, and this is also in our construction agreement, where we provide that the association is not liable for any cost increases that are associated with labor, equipment, materials, and supplies that arise during the course of the work without a written change order. Now, some of you may be thinking, oh, goodness, we've heard all this news lately about tariffs. So a lot of times right now, this is really a pressing issue, and it certainly happened during COVID, where, the market for certain materials, it's unknown. And sometimes there's price changes that happen daily. So to help associations in that regard, we certainly have drafted language and agreements that allow for and provide for that the contractor will cover the first X% of any increase to materials. And then the association will cover the remaining percent. And believe it or not, a lot of contractors have been very receptive to this. To also help kind of obviate this, we've also included language on occasion, which provides for that the initial down payment for the project that the association is giving the contractor, that all of those monies are to be specifically used to buy materials up front to help reduce any impact of buying materials down the road that might increase in price. So it's very interesting. Sometimes we're very much able to turn a potential negative into a positive and a win-win for both sides. And as Jeff had alluded to in builder's risk insurance, in conjunction in that are payment and performance bonds. And a payment bond is essentially designed to ensure that the contractor pays its subs and material suppliers and laborers, And then conversely, a performance bond is really designed to ensure the completion of the project. It is very, very rare that we would not recommend that the insurance or that the association have the contractor obtain payment and performance bonds, especially on a larger job in a considerable length of time. Now, sometimes there may be contracts that are short and sweet, very low dollar amount that can be accomplished very quickly. Then we'll have to do a cost benefits analysis. The payment and performance bonds, they're often sold as a set. They're acquired by the contractor. And typically we have seen them cost anywhere between 3 and 5% of the total contract price. Now, recently I've dealt with some elevator modernization contracts where the elevator contractor has been able to procure these bonds at 1 to 2%, but I have not yet seen that for other projects, whether it be roofing, whether it be concrete restoration and repair, asphalt paving, things of that nature. So we generally see it at 3 to 5%.
And Ben, can I add to that the payment and performance bond, which is really where my comments were better directed from earlier, is worth its weight in gold. When the proverbial poo hits the fan and that contractor is no longer there because they're out of business, man, are you glad you have it. So for 3 to 5% total of the contract price, including change orders, it's an insurance policy to make sure the job gets done. And on the few occasions where we've had to actually activate those bonds, the client sure was grateful they had made that decision.
And this harkens back to something, Jeff, that you said at the very beginning of this presentation.
What's that?
That an ounce of prevention is worth a pound of cure. And ladies and gentlemen, this is certainly applicable here. And as I originally mentioned, when we were talking about the notice of commencement, the copies of the payment and performance bonds are recorded and they're included as an exhibit to that notice of commencement.
Hey, Ben, since you brought up the notice of commencement again, I'll also point out that the obligation of the notice to commencement is on the association to make sure that it is executed and recorded. Oftentimes, Ben and I do something very unique that I haven't seen other lawyers do, which is we put the obligation on the contractor to make sure that the association executes and that the contractor records on behalf of the association so that if it doesn't happen, then we have some legal remedy arguments against the contractor who failed to comply with that contract term. Because if you don't have the notice of commencement in the public record, in addition to some other situations where Ben explained you may end up paying twice. Boy, if you don't have that notice of commencement recorded, then the subcontractors don't know where to send their notice to owners. And you pay the contractor, you don't have that notice of commencement recorded, you're absolutely in danger of paying twice. So bear that in mind.
And moreover, a lot of times if you don't file, the association doesn't file a notice of a commencement, guess who's not getting their permits? So a lot of times these local building, whether it be city of West Palm Beach or Palm Beach County, will specifically require that notice of commencement in order for the association or in order for the contractor to procure permits. So
right, if that notice of commencement is not recorded, courts have no problem having an association pay the contractor twice. You paid the general contractor, he didn't pay the sub. If that notice of commencement isn't there, meaning you didn't get the notice to owner, then you don't have the protection you would otherwise have from the statutory regime. So the notice of commencement and the notice to owner process is all about protecting you, the property owner. Even though it may be a pain in the tuchus from time to time to get that done, it's there for your association's protection. Don't miss that step.
And ladies and gentlemen, pain in the tuchus is a very specific legal term.
Very good.
Legal term of art. Number 5, question. What does it mean if your general contractor tells you that they cannot or will not get a bond? So contract pro tip, right? Much as we might want to explore and figure out the red flags in our personal relationships, this is an area where we want to explore the red flags in our contractual relationships. Because oftentimes, if a contractor cannot be bonded, it means generally that they have a poor track record. They might not be properly capitalized, may not have sufficient assets. They might be getting sued up, down, left, and right. They likely have a bad reputation. And so generally, you want to make sure that your contractor is able to be bonded. And then termination. So interestingly enough, and this may apply to some of you out in the virtual land as well, is a lot of people mistakenly believe that they can terminate a contract at any time and for any reason. But however, it's really the language that's included in the contract itself that really governs how and when a contract may be terminated. You know, oftentimes we'll get calls from an association and they'll say, hey, we'd like to terminate this contract. Well, we start reading through it and realize, oh my gosh, you know, this contract is for a term of 10 years. And the only way out for the association is to give notice 90 days prior to the expiration of that 10-year term. And for those of you that have ever signed a bulk services agreement with a cable provider, or for any of you in a condominium association that may have, be still my heart, a laundry lease. Oh my goodness. Those things are tying you up for generations upon generations. And so oftentimes it's very difficult to get out of those contracts. So when we look for a good construction contract, we look for ways that it can actually be terminated. And several of the ways that we want to see is, number one, we want to make sure that it's can be terminated by the contractor for cause, right? If the association doesn't pay the contractor, well, that can certainly be a reason for the contractor terminating the agreement for cause. Likewise, you know, we want the ability for the association to terminate the agreement for cause, right? If the contractor doesn't, you know, do what they're supposed to be doing, if they're not following the contract documents, they're not following the project manual, they're not supplying enough employees to get the job done, if they're breaking, you know, laws, ordinances, getting into trouble, if they're, you know, facing a potential bankruptcy or have a receiver assigned, meaning their financial health is in doubt. We want to make sure that the association can get out of the agreements for those particular reasons. And we also want to make sure that the association can get out without cause. And sometimes this is referred to as termination for convenience. Now, in our particular construction agreements, we always try to provide the opportunity for the association to terminate the agreement by providing 30 days notice to the contractor. You know, everything is all sunshine and roses until it's not. And so we want to make sure that, look, when the relationship goes south for whatever reason, that there's a nice, easy way out for the association. And that 30-day clause generally addresses that, because if for some reason the board becomes upset, or, you know, there are issues that may not rise to the level of a material breach, but there is ongoing dissatisfaction or unhappiness with the contractor and its work, then we want to provide that opportunity for the association to get out. And then that last box there at the bottom, you know, this is an interesting tidbit. An improperly terminated contract minimally entitles the contractor to profit and overhead, which could be 25% or more of the contract price. And so, you know, you might be able to terminate, but there's certainly a cost in doing that. So When we draft our construction agreements, we want to make sure that the contractor's damages, in the event that the association does terminate that agreement, are held to a reasonable percentage. And typically we see that percentage being anywhere between 10 and 25% for anticipated profit and overhead on the remaining contract price. And with that, I will close out my portion. And if we have a moment, I don't know how we are on time. Looks like maybe we have run over by a few minutes, but potential.
Excellent job. Excellent job. No, we're in good shape. We're in good shape.
Okay.
I just want to mention everybody that if you haven't already opened your chat, do that now. I'll place the link in there for a third time. So the evaluation link is there. After you click the link, the evaluation opens up in your browser. You fill that sucker out. And after you fill that out, you'll get a confirmation screen with all kinds of links for contacting everybody on today's webinar, as well as the link to download today's course materials. And lastly, links to our upcoming events for the rest of the month. We have a few questions in the Q&A. If you guys want to check them out.
Happy to do it. Quirine asks, did I say the notice of commencement is on the contractor? No. The law says in the statutes, the notice of commencement is up to the property owner to execute and get it recorded. What we do in our construction contract is add a provision that says basically, notwithstanding that obligation, the contractor shall ensure the property owner signs it and that it gets recorded. Benefit to that is if for some reason it doesn't happen, at least you then have another remedy against the contractor. Usually that would be on only the property owner if it doesn't get done. But this way, my thought process there is to shift some of that liability over to the contractor, just as another means of remedy, if at all possible. If a board member or regular association member, David, cannot afford an increase in the budget, well, sadly, that happens, and that's why we have collection foreclosure. As heartless as that sounds, I don't mean it to, but it is a reality of living in a condo HOA, right? If your house gets damaged and code enforcement says fix it and you don't, what happens at the end, right? You're going to have some problems. You could end up actually losing your house at the end of the day. How often throughout a project should we reconfirm with their vendor regarding their insurance and licensure coverage? Well, whenever you check insurance, you can certainly check licensure, and you will know when the insurance of the vendor is going to lapse, because you will be, hopefully, as been alluded to earlier, you will be listed as an additional insured on the policy, but you will have a date by which that policy is going to lapse and it needs to be renewed. You should put that on your calendar and then confirm and get another certificate from the contractor to make sure they still have the coverage. Regarding Rachel's question, we, the managers, ensure the agreement between the association and vendor should clearly outline vendor will not be utilizing third-party workers. Well, that's sometimes. If the contractor says we have all the workers in-house, then we would add that provision. It just depends on the scope of the job and whether they'll be using subcontractors and other labor sources and things like that. Is there a sample blank construction contract? Well, there is, insofar as for our clients, and when we know they're going out to bid a project, we provide a basic, unfilled out, non-adapted contract that we want the association to use for that job. And then by putting it in the bid package, it basically obligates the contractor to do so. So there's your answer, Christine. And Mark, what is the law on contractor substantial performance when some workmanship and defects still exist? Well, that's an interesting question. The law on the contractor substantial performance. Well, I don't know of any particular law that addresses that in the same way the question is asked. We're going to look at the contract and deal with what the term substantial performance is, who gets to determine what substantial performance is. And when there's workmanship and defects, we have the Chapter 558 process. Sometimes it's good, sometimes it's bad, but it's a forced mediation statute that is rather complicated. It could certainly be a whole lot simpler, but it is a forced mediation statute to hopefully keep the parties out of litigation. If after the job is done and then you're still having defects and such, then you're going to be activating warranties and dealing with all of that issue as well. So there really isn't a straight answer to your question, Mark, as much as it is. That's why you need a really good contract to define what substantial performance is as well. And then, if you need to, you involve our construction litigation department to go after the workmanship and defect issues and turn it over to them and let them work their magic, which is handled by my partner, Jeff Green, board certified in construction.
How many Jeffs do we have?
How many Jeffs do we have? We have Jeff, me, Rembom, Jeff Green, we have Jeff Solomon, and who knows, maybe we'll hire another one.
All right. It looks like there might be one more there. See if that's pertinent. And while you're looking at that one last question, just want to mention to everybody one last time, there is a link in the chat. Click on that sucker. And when our panelists leave, I will remain on for a couple of minutes to go over the evaluation process much more slowly for everybody, for anybody still having issues. Jeff, back to you.
Sure. Karine, to answer your question, should there be wording in a contract where the construction debris from sawing material goes? Well, you could have. It's not obligated to do that, but you certainly could have had a provision. I have a circle saw at home where it has a built-in catch. So the wood, the plywood dust, if you will, the 2x4 dust, just goes into a bag. I don't have to worry about it going into the water, to your point. Lots of different ways to deal with that. It has to be thought about in advance. Let's go back to what I said, to what Ben said, and I'm going to reiterate it. An ounce of prevention is worth a pound of cure. You're doing that type of work on the docks. You had every opportunity to deal with the issue, and you are most welcome.
Well, thanks to everybody. Courtney, I'm going to turn it over to you for our parting words. And remember, folks, I will remain on, turn the chat on for any technical questions. Courtney, thanks for having us.
Thank you. Thank you so much for having me. Big thank you to Jeff and Ben. That was great. Just as good as when I saw it live a few months ago.